the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court previously ruled on this issue that allowed the state to use this information in their argument. The new information, as I've laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans, and for going to the airport and for stepping on the jet.
If I'm recalling prior counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct, Your Honor.
So, response, Ms. Kaufman?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Well, I believe that covers the defense motions. And Ms. Kaufman, you stated that the state did not have an additional motion in limine that not already been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Newell and Patrick Sanford.
Oh, yes. Go ahead as that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Kaufman, response?
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Kaufman, even though it might be inquired into at deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course. There is no reason to elicit it at deposition, and it could never be admissible at a trial. So we're just wasting paper and time with these motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by either Investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. I don't really see a context in which this might come around, either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of the jurors on the issue of pretrial publicity, similar to what we did in the last trial. The The court will be asking these same questions, or substantially the same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screening process, anyone who has had an issue, or either the court believes, the state believes, or the defense believes, is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that prospective juror, and they'll be told to return, or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are.
Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your Honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they are seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broke it up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
Defense would request 3, Your Honor.
Very well. Then once we have our 12 jurors and 3 alternates, at that point we will swear them. If we have enough time to actually move into opening on that same day at the selection, we'll do that so that way we can start to begin into the witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7, so 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Let me bring up my calendar. Assuming that we have a jury by Friday the 22nd, we'll know that in place August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes, sir.
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I need one other hand, unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trail to finish. All right, 8:25 through 9:02, then, estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for openings only, does the defense have a position concerning this?
Good. We don't want to make the openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer your opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
All right. On that matter, again, depending on where we're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calvin?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is a comfortable range, Judge.